In this lesson, what we're going to do is continue on talking about legal positivism and focus on one of the most major critiques of legal positivism, and that being a critique from the jurisprudential theorist Ronald Dworkin. And so what we're going to do is look at a little bit, briefly look over what legal positivism recognizes, what legal positivism argues, and then look at the critiques of those arguments from Dworkin specifically. So first of all, who was Ronald Dworkin? He was a legal theorist who lived between 1931 and 2013. He was a professor of law and philosophy at the NYU and also at UCL. He also was the chair of jurisprudence at the University of Oxford, and he has philosophical influences including the likes of Hart, who he will later critique, as well as Quine, who was a metaphysician, somebody who studied metaphysics and language and looked specifically at things like modality. So we can really see that his jurisprudential tradition is quite strong. He's very, a particularly intelligent individual, and his works can be described as a reaction to modern legal positivist thought and the thought of positivism that was described by people like Hart. So let's recap what Hart's legal positivism argued, or at least a couple of the major aspects that Dworkin would later critique. So effectively, Hart described law as a series of rules. Don't forget from the last lesson, the series of rules being there being some primary rules and there being secondary rules, and we're having things like rules of recognition, for example. And an important aspect was the rule of recognition, the concept of the law being something that is recognized. Okay, and so really, this is an example of the rule of recognition that Hart outlined in his concept of law. He said that the rule of recognition providing the criteria by which the validity of other rules of the system is assessed, an ultimate rule, and where there are several criteria ranked in order or relative subordination of primacy, one of them is supreme. So we're talking really about describing what the rule of recognition is, and Dworkin takes a very major critique to the rule of recognition. Specifically, Dworkin begins by critiquing the positivist conception that law contains rules, or that law only contains rules, because he argued that law can also contain non-rule standards, in quotation marks, non-rule standards. And Dworkin called these principles. So he made a delineation between rules from a positivist perspective, a positivist sense, and he also said that there is a distinction between them and these non-rule standards, these principles that exist. And the existence of principles are not necessarily to advance some kind of socio-economic or socio-political telos, some kind of end goal, and rather to fulfill the requirement of justice or fairness or, quote, some other dimension of morality. So I think you can notice a little bit here that Dworkin is incorporating what we would describe as more transcendental ideas such as morality into legal positivist thinking and to legal thought, and so that's something that a positivist would reject. So let's look specifically at the arguments against positivism. Dworkin discussed a number of cases to illustrate the point, the distinction between a principle and a rule from a legal positivist perspective. And one of the very good examples is the case of Riggs v. Palmer from 1889. Now, effectively, the facts of this case are very simple. In this case, the defendant had murdered the testator of an estate that he was going to inherit. And under the law at the time, it would have been required that the estate change hands to the defendant, even though the defendant murdered the testator. And it was held that by the judge that no one shall be permitted to profit by his own fraud or acquire property by his own crime. So it recognized that even though the law at the time, the rule at the time, was that even though the defendant had murdered the testator of the estate, they were allowed to inherit the estate that they were a beneficiary of. And effectively the judge said that even though this is the case in law and this is the rule in law, there is some kind of moral aspect that should be we should apply, because nobody shall be permitted to profit from one's frauds or acquire property from one's crimes. And they go on to continue this by saying that this maxim, the idea of not profiting off fraud or acquiring property from crime, that these maxims are dictated by public policy and have their foundation in universal law administered in all civilized countries. So the judge in this case is acknowledging that the existence of some kind of universality of the legal principle that that one shouldn't be able to be permitted to profit from fraud or acquire property from crime. And Dworkin argues that this is how a principle operates. He acknowledges that this is how we can see that there is a general rule from a positivist perspective, the rule that the defendant can inherit the estate of the testator. However, Dworkin says that this principle, that there are maxims that are in place that allow for the punishment of a defendant, and that they should not be able to inherit an estate because they have murdered the testator. So Dworkin argues that this is how a principle operates. And a principle is able to override an established legal rule in this sense, because the established legal rule was what we had already discussed, and the judge overrode that established legal rule by talking about these maxims of public policy. Now, fundamentally, Dworkin argued that the difference between legal rules and legal principles are one of logical delineations. There's a logical distinction between the two. They can both point to a particular decision about legal obligations, but they will differ in their character. And this is given in the quote here: principles have a dimension that rules do not, and that the dimension is that of weight and importance. So let's go back to the rule of recognition and talk a little bit more about it. We've already seen that Dworkin rejects Hart's view of the rule of recognition. He rejects the notion that there exists some kind of master rule, and that this, in every kind of legal system, that is utilized to identify where a rule is a rule, where a law is a law, where a law is valid. And this is because Dworkin argues that this rule of recognition would entail that there be some process of identifying law that can be done with relative ease. Now, Dworkin rejects the idea that we can use the rule of recognition to find a process of identifying law quite easily, because there are often hard cases within law, and this is something that Dworkin references a lot. The example of hard cases, and even in those hard cases where the correct legal outcome is disputed, there is not a situation where people still don't have legal rights in those cases. And so we have examples where we have difficult cases where a rule of recognition is unable to reconcile the differences and the distinctions. And Dworkin uses a thought experiment. He highlights the experiment of maybe some legislator passing a law that says that sacrilegious contracts are invalid. And that was the law that was passed. And then there was a distinction that was made because somebody asked the question, well, what about this contract that was signed on a Sunday? And then the question was, and then from there we get the kind of distinction and the kind of difficult cases that exist, because we have on one hand legislators that are arguing that sacrilegious contracts should be null and void, but on the other hand we've got a question of what this actually means, and an interpretation of the law by the legislature is something that wasn't done. And so we have these hard cases where there is not actually one correct answer. And so this brings us to a question of law and the influence that morality plays on the law. And Hart's positivism argues that law and morality can and should be separate. That's what Hart argued when he talked about legal positivism, that there is a separation between morality and other transcendental ideas and law. And this is obviously codified in his separability thesis, something we've looked at in the previous lesson and in the lesson before that when we looked at Austin's positivism. However, Dworkin argues against this, And he cites that constructive interpretation of the law must necessarily implicate moral judgments when it comes to decisions about what the law actually is. So Dworkin rejects the idea that we can just simply separate law and morality, because morality is necessarily implicated when it comes to decisions of law, especially in very difficult cases, in the hard cases that we're thinking about. Before we finish, I want to talk about just quite a famous response to Dworkin and a defense of legal positivism from Joseph Raz. And Dworkin's critiques were significant because we're doing an entire lesson dedicated just to Dworkin, and B, because it played into a number of debates about legal positivism. Positivism being one of the major jurisprudential theories of law. Joseph Raz was somebody who was a defendant of legal positivism and decided to attack Dworkin's conception, specifically focusing on the rules versus principles distinction that Dworkin made. He argued that most principles in the Dworkinian sense, as we will describe it, the Dworkinian principles are not statements of law, but simply statements about the law. So we're getting to a distinction between the fundamental aspect of law rather than just a statement about what the law is. And so therefore, according to Raz, when judges apply principles of law, they're actually just applying principles about law rather than some underlying judgment based on binding legal standards. So we can see here that Dworkin's Dworkin's critiques of legal positivism have been subsequently critiqued themselves, and there's a rich debate that exists within legal positivism and within Dworkin's critiques. And what we'll do in a few extra lessons is talk about a number of other critiques that can be made of Dworkin's critiques, and also maybe even deep dive even more into Dworkin's critique of positivism more specifically.